Thank you very much for the kind welcome and for the invitation, which I very much appreciate. And yes, greetings from Manchester. I hope that everyone is well. And I know, of course, it's a very difficult time at the moment in Ukraine, and I'm sending well wishes from the United Kingdom. I myself am Australian, actually. So I'm an immigrant here as of a couple of years ago. But I do, as a lecturer in law at the University of Manchester, I do work on the human rights system in the UK. And as I think the introduction mentioned, prior to this, I was at Cambridge doing a PhD. So to start the lecture, I wanted to first show this very nice picture of the Tower Bridge in London, which I took about a year ago. And I'm trying to maybe abuse my privilege as lecturing to show some nice photos of London off. And the topic of the lecture is on the protection of human rights in the UK, which is quite an interesting issue because the UK's method of human rights protection is not exactly the same as some other countries. It's one in which there's a softer kind of protection where courts can't strike down laws on the basis of human rights violations. And that's the detail that I'll be focusing on, I suppose, throughout the lecture. So to turn to the turn firstly to this overview of the lecture. So I'm going to be talking about the historical relationship between the UK and the European Convention on Human Rights, the Human Rights Act and its key provisions, which we'll look at in some detail, proposals for reform, and then we'll ask some questions about is the current system working, because it continues to be quite controversial in some quarters, particularly among the Conservative Party in the UK. There's quite a strong constituency who think that the current system gives too much power to judges. But as we'll see, it's one in which there's actually quite a lot of limitation on the power of judges. So I suppose the question is, does this strike the right balance, particularly from the standpoint of the UK's historical emphasis on the concept of parliamentary sovereignty, which is often interpreted as the idea that Parliament should have unrestricted power to legislate. So that's something that we'll be looking at. So to begin with, the UK is obviously a party to the European Convention on Human Rights. It played a significant role in drafting the convention. And it's sometimes said that its representatives or its participants in the drafting process sought to add more detail compared to broad statements of rights. And this was a role that the UK played. The convention was ratified by the UK in 1951, and then it entered into force in 1953. The UK went on to accept the right of individual petition in 1966. And we have here a picture of the European Court of Human Rights, which I suspect everyone has already seen before. I think it looks a bit like a spaceship, personally, but I'm not sure that it's ever taken off. And the UK very quickly found itself before the European Court of Human Rights and lost in some significant cases, not in all of these cases that I list, but I think the assumption in the UK when they signed up to the European Convention was that the UK law already adequately protected human rights. And so perhaps it was surprising to discover or to be told by the European Court that in some ways the law in the UK fell short of human rights standards. So the cases that I've highlighted here, Handyside, which related to a book and a freedom of expression issue with a book that was considered obscene. So no violation in that case. Ireland and UK, very famous interstate case involving interrogation techniques that were used during the so-called Troubles with Ireland over the Northern Ireland issue. And it was found by the court that the UK had violated Article 3 of the Convention in some of the techniques that they had used, but that it didn't amount to torture, which was quite a controversial outcome, recently revisited by the court, and they didn't disturb that finding, which is quite interesting, I think. But nonetheless, an Article 3 violation. Then in dudgeon, the issue was the criminalization of homosexual acts, and that was found to violate Article 8. And then quite famously or infamously, depending on your perspective, in McCann, there was an issue around the killing of some Irish terror suspects associated with the IRA. And it was found that that was a violation of the negative obligation under Article 2 in certain aspects of how the operation was carried out. So what we're seeing, I suppose, is that the UK, despite its perhaps assumption that its human rights record was rather pristine, did find that it was being called to task sometimes by the European Court, which leads into the issue with the Human Rights Act, which will be the main focus of this lecture. So because domestically convention rights weren't enforceable directly under UK law, there was this question of should the UK do more to actually enable people in the UK to protect their human rights or their convention rights. So there were certain ways in which the convention was relevant, I suppose, to UK law. One area was if the statute was ambiguous. Convention rights, the statute in question was ambiguous. Convention rights could be relevant to the interpretation of the statutes, at least according to some cases. There was sometimes a higher level of scrutiny in the administrative law context if you had interference with rights. And also there was this famous concept of the principle of legality, which was the idea that fundamental rights couldn't be overridden through the general or ambiguous words of a statute. So this interpretive approach that would be addressed to a fundamental common law right if there was interference with that kind of right. So prior to the Human Rights Act, there were these approaches in place that offered some human rights protection, but what we didn't have was the convention rights actually implemented in domestic law in the UK, laid out in a statute, and you couldn't go to court and argue my convention right has been violated. So that's what changed with the Human Rights Act. So the Human Rights Act was introduced under the Labour government that came to power in 1997. We have here a picture of Tony Blair. He was the Prime Minister at the time that all this happened. That's a picture from 2010. He looked rather more youthful back when the Human Rights Act was enacted. It still looks fairly youthful there, I think, but relatively speaking, he was particularly youthful when he became Prime Minister in 1997. And the idea was to bring rights home, bring them back from the European Court where violations were sometimes being found in the context of the UK, and make it enforceable in the UK, bring the UK courts into the picture in terms of considering the convention rights and enforcing the convention rights. So the result, as I say on the slide, was the Human Rights Act, and it entered into force on the 2nd of October 2000. So it's been around for 23 years, and that makes it relatively old, I suppose, but it's quite young in the span of the UK's constitutional history, which obviously spans several hundred years. So this is still a relatively new constitutional development for the UK, and arguably a very significant one, because it does in fact empower the courts to consider or to evaluate primary legislation passed by the UK Parliament, which it, depending on your perspective, perhaps couldn't do before. So I'll now go through some of the key provisions of the Human Rights Act to give you a sense of what this act involved. And I've got the actual text of the provisions extracted, so you can see exactly what it says. Although I think Zoom is actually obscuring some of my, I've just moved the window, okay. Some of the screen for me. So section 2(1)(a) says, a court or tribunal determining a question which has arisen in connection with the convention right must take into account any judgment, decision, declaration, or advisory opinion of the European Court of Human Rights. So this governs the relationship between the UK domestic courts and the European Court. The language, though, is not super clear about how influential the European Court's decisions have to be on the UK domestic courts when considering human rights. The concept of must take into account is not unambiguous, and we'll get more into the interpretation of that provision shortly. Then there's section 3(1). This is a very important section. It says, so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the convention rights. So this provision empowers courts to reinterpret both primary legislation and subordinate legislation consistently with convention rights, and it's a very significant provision. It's also quite controversial, and as we'll see in due course, some of the proposals for reform have targeted this provision in particular because of the idea that it gives judges the power to rewrite legislation, but perhaps that's not a fair criticism. So we'll have to see more about that shortly. So in terms of the interpretation of section 2, there's this idea that there's a kind of mirror, I suppose, between the Strasbourg case law and the domestic courts. But the position is maybe not exactly a mirror. So we'll have a look at that through these quotes. So in one very early case, it was said that the duty of national courts is to keep pace with the Strasbourg jurisprudence as it evolves over time, no more, but certainly no less. So that's this idea that we have to, in the UK, broadly mirror the Strasbourg jurisprudence. But then it's qualified by this idea that you actually need a clear and constant set of case law, and there could be special circumstances that justify departure from Strasbourg case law. And sometimes you'll see that in the UK context, that they do not always follow Strasbourg. The other side of the coin is the no more side of it. So should the courts go no further than Strasbourg? And it was said recently in Elan Kane, a case of the UK Supreme Court, that protection can go beyond situations previously considered by the European Court, where the principles established by that court enable such a step to be taken. So we're not necessarily limited to what the European Court has already decided. And here's an example. In Rabone, a woman who had been admitted to hospital for treatment for depression after a suicide attempt was granted home leave and then hanged herself very, very sadly. And in that situation, the UK Supreme Court did find a violation of one of the positive obligations under Article 2 of the Convention, the operational obligation, even though the Strasbourg case law hadn't at that point precisely addressed this mental health type situation. The UK Supreme Court applied the general principles under Article 2 to reach that conclusion. So sometimes the domestic courts will go a little bit further than Strasbourg. But that's also controversial, and Rabone in particular has been the topic of controversy among some on the political spectrum in the UK, who argue that the court shouldn't have taken this step without Strasbourg having reached a very similar conclusion in a similar case, I suppose seems to be the thinking. So we talked about the Section 3 interpretation power as well. I'm just going to give one example, which I think is often viewed as the most significant example of a Section 3 reinterpretation or Section 3 interpretation that we've seen in the UK. In the case of Guydan, the issue was a provision of the Rent Act. And it was interpreted to enable a surviving tenant who was part of a same-sex couple to succeed to a tenancy that was held by the deceased partner. So the language of the statute seemed very much to be limited to a married opposite-sex couple, but the language was reinterpreted by the House of Lords to extend to same-sex couples in order to avoid a violation of the European Convention. And as I said, this is often held up as a very significant reinterpretation that some people think goes too far, but in most cases are not as significant as this. So many of the interpretations that we see under Section 3 are much milder, and often, in fact, in human rights litigation, the UK government is one who says, well, we would prefer a Section 3 interpretation rather than a Section 4 declaration of incompatibility, which is what we're about to get to next. So it's an option that saves it getting to the point of a declaration of incompatibility, which sometimes can be viewed as a good thing even from the government side of the picture. So now I'm getting into the declaration of incompatibility and also Section 6 of the Human Rights Act. So Section 4(2) provides that if the court is satisfied that a provision of primary legislation is incompatible with the convention right, it may make a declaration of that incompatibility. So this is a really significant power, but very important to note is that it's not a strike down power, it's only declaratory. So if a court makes this declaration, presumably because it can't reinterpret under Section 3, then it doesn't lead to the invalidity of the primary legislation. And Section 6 is also very important in practice. It provides that it is unlawful for a public authority to act in a way which is incompatible with the convention right. So that's very significant because that applies to a range of different agencies. So that they have to comply with convention rights. Impact of sex at government agencies, it still had an interesting impact on the development of UK law in certain contexts. So one aspect of Section 6, which I just mentioned, is that it extends to the courts as well. The courts are also a public authority. So what the courts have found is that, that means we have to develop the common law, which is to say the court-made law of the UK or of England by reference to human rights as well. So here's a very significant example. In the common law in the UK, there was no right to privacy. But after the Human Rights Act, a new tort was developed called the tort of misuse of private information to protect people's privacy from, for example, the press. And that was done on the basis of Article 8 of the European Convention, which is quite interesting because the Human Rights Act doesn't itself give two private individuals the ability, or one private individual rather, the ability to sue another private individual under the Human Rights Act. But nonetheless, the courts developed the common law to enable this tort of misuse of private information to be used against another private individual. And this is what's sometimes called indirect horizontal effect. So the horizontal effect being between two individuals, and indirect because it wasn't directly provided for by the Human Rights Act. As distinct from vertical, which is between the state and the individual. So in terms of Section 4, this is a really significant power because it does allow the courts to look at primary legislation and say, look, there's a problem with this primary legislation, which is something that courts have generally not done in the UK context. So I give the example of Steinfeld. This was a case in which that related to the Civil Partnership Act, which had been passed prior to the provision for same-sex marriage in the UK, and this allowed for people of the same sex to become civil partners. So the issue in the case was actually, is it discrimination that it doesn't extend to opposite sex couples? And the UK Supreme Court said, yes, it is discrimination. It violated Article 14 read together with Article 8. So they issued a declaration of incompatibility under Section 4. And so that shows, interestingly, I suppose, that this is a remedy that is available to the UK courts in circumstances where they don't think that any problems can be resolved through reinterpretation or through interpretation of the statute under Section 3. And it really says to the UK Parliament, oh, no, you have got it wrong, basically. So I suggest it's a novel remedy, and this is a widely observed position, because it doesn't strike down the legal validity of the primary legislation. And that's consistent with the UK's constitution, arguably, because it preserves the lawmaking power of Parliament, which is associated with the concept of parliamentary sovereignty. But the declarations of incompatibility usually acted upon, and so that makes them quite potent in reality if the government and the Parliament. So according to the latest figures from the Ministry of Justice, 46 declarations of incompatibility have been made since the Human Rights Act entered into force in 2000 through to July 2022. And of these, 40 have been fully addressed. So either turned on appeal or actually responded to by the government. And something of that nature. So they're taken seriously. The government's not just shrugging off a declaration of incompatibility. It does in fact feel the need to respond meaningfully, which goes to show that it's not quite as weak a remedy as it might look like. Of course, some might argue actually the government or the Parliament should be disregarding declarations of incompatibility, because that's the whole point, arguably, that not every single declaration needs to be acted upon, because it's meant to be only a non-binding declaration. But in terms of the HRA, so Section 10 to provide compelling reasons for proceeding under this section, he may by order make such amendments to the legislation as he considers necessary to remove the incompatibility. And I've just explained the rest of the section, which is that this is after a Section 4 declaration of incompatibility or an adverse European court decision. That's essentially when this provision will kick in. So what does this mean? Well, it means that the government can actually use subordinate legislation to amend acts of parliament to address human rights problems. So some would say this is a slightly troubling power, because it should be, arguably, it shouldn't be a commonplace practice for the executive government to be amending acts of parliament And in practice, actually, this hasn't been used so much, and mostly when the UK government wants to address a human rights issue, for example, after a declaration of incompatibility, generally speaking, they will go to Parliament with some legislation, with a bill rather, and Parliament will act. So it hasn't been used all that much. Some would say this section raises some concerns, I suppose, about about sidelining Parliament from the discussion, potentially, but maybe those concerns haven't been realized too much in practice, possibly. And finally, this is also quite important section must, before second reading of the bill, make a statement to the effect that in his view the provisions of the bill are compatible with the Convention rights, or a statement to the effect that although he is unable to make a statement of compatibility, the government nevertheless wishes the House to proceed with the bill. So this is obviously quite important as well, because this involves a kind of additional step by the government in proposing legislation to the Houses of Parliament, that they're actually going to think about human rights, and they're actually going to have to make a statement to the effect that there's compatibility, or that they cannot make such a statement, which will draw attention to the human rights issue, even if it's not necessarily a guarantee of anything. And this ties into the question of parliamentary scrutiny of human rights. And one really important aspect of that parliamentary scrutiny is the Joint Committee on Human Rights. This is a committee that comprises 12 members. It's drawn from the House of Commons and the House of Lords. And so it's a joint, that's what they mean by it being a joint committee. It's both houses of Parliament. And the committee examines government bills for compatibility with convention rights. It publishes reports. So it weighs in on these questions that we were just discussing a moment ago about whether the government's proposed legislation is actually compatible with human rights. And also, I'd like to draw your attention to this photo that I took of Big Ben in London, which is quite lovely. And they've recently, I suppose you'd say, refurbished it. So it's particularly spectacular at the moment. So what I've described is the way the Human Rights Act works. And as I alluded to earlier in the lecture, it's not uncontroversial. It's actually quite controversial. It was a Labour Party reform, which is the centre-left party in the UK. And the Conservative Party, the centre-right party that's governed the UK since 2010, isn't quite as enamoured of it as perhaps the Labour Party was when it was passed, although actually the Labour Party itself has at times, or some people in the Labour Party have at times had concerns about it. So the Conservative Party manifesto, for example, has pledged at different points to scrap the Human Rights Act or to update it. So maybe you might question what update means, but there's been continuing concern from the Conservative Party, I suppose, expressed through its manifestos, that something needs to change about the Human Rights Act. And broadly, their critique is that the Human Rights Act gives too much power to judges, as distinct from the democratically elected parliament. So having seen the provisions, you can form your own view, I suppose, about whether that's fair, because as we saw, it doesn't give all that much power to judges. They can't, in fact, strike down laws. It's very different from the US system, where the US Supreme Court is constantly, well, it seems perhaps that it's constantly striking down laws made by Congress. This is a much more limited power in the case of the Human Rights Act, but we did in fact see that the declarations of incompatibility are usually followed. So perhaps the power is greater than it seems. Now, very recently, in 2021, a consultation was held over a possible replacement for the Human Rights Act, proposed by a Conservative Party politician. And the idea was to create a British Bill of Rights. And this idea of having this British Bill of Rights has been floating around for many years as an alternative to the Human Rights Act, which is viewed as perhaps too European in nature, or not sufficiently British, what would be a different way to put it. So the British Bill of Rights, the Bill of Rights Bill, had a number of different proposed suggestions, but perhaps surprisingly, it didn't really alter things. It wouldn't have, I should say, it wouldn't have altered things quite that much, because the Section 4 Declaration of Incompatibility power would have remained in this new bill. So it did repeal the Human Rights Act, but then it proposed to enact a new British Bill of Rights that preserved the convention rights that were listed in Schedule 1 of the Human Rights Act and preserved the Declaration of Incompatibility power. But it did make various changes that were quite negatively received by the human rights community in the UK, or I should say it proposed to make various changes that were negatively received. And perhaps the most significant change that was proposed was eliminating the Section 3 interpretation power. So that would have meant that courts had to make Section 4 declarations of incompatibility more than they currently were. And it also had quite quixotic, possibly, attack on positive obligations, because there was some concern from the police in the UK that the positive obligations that existed under Article 2 of the Convention, particularly the operational obligation, which we mentioned earlier in the context of Rabone, proved to be too onerous for the states to deal with. So the operational obligation might require the police to notify people who they're aware might be in danger of being killed, for example. And that was viewed as potentially burdening the police. That was too much. There was a waste of police resources, at least in the context of some of the people that were warning who might be career criminals or something of that nature. So these were some of the concerns that were raised. And I think for some of us in the human rights community, this was not a hugely persuasive critique, because the idea that you can protect the right to life under Article 2 of the European Convention without the state taking any positive steps to protect it seems to render the right very artificial or hollow even, because it's probably not enough for the state just to refrain from killing. It has to, except in the circumstances permitted under Article 2, it has to take steps to prevent private citizens from, or private persons from killing one another, arguably. So I think this notion of positive obligations coming under attack, I think, was quite bothersome. There were various other provisions, but in the end, it doesn't really matter, because the bill, even though it was introduced into Parliament, wasn't proceeded with in the end, and it was withdrawn in 2023. And I've got a picture here of its of the person who was the key figure in the UK government behind this project. So I suppose this leads into my big question, which is the current system working? Should we feel satisfied about how human rights are working in the UK, given these proposals for reform or even repeal and replacement of the Human Rights Act? Another aspect of it that I want to draw your attention to is this clash between the European Court of Human Rights and the UK government over voting rights, after the court held in this case Hurst that the UK government's blanket ban on prisoners voting was a violation of Protocol 1, Article 3. And the UK actually was very critical of this decision, and for years they just didn't comply. Ultimately, they made only some minor administrative changes that didn't affect very many people, granting voting rights to prisoners who were on temporary license, so they weren't in custody in the sense of being in a prison. And the blanket ban has essentially persisted. So in a sense, the UK ignored this judgment or did only token measures to address it, depending on your perspective of how much they addressed it. But the Council of Europe said, this is enough. We are satisfied. So there have been clashes between the UK and the European Court, and this is perhaps the classic example. More recently, there have been some calls by the Secretary of State for the Home Department to withdraw from the European Convention, which is quite a big call. But there's an ongoing dispute, perhaps, or maybe potential dispute over some migration issues, because the UK wants to send asylum seekers to Rwanda, and there's a concern that this might not be permissible under the European Convention, but that remains to be conclusively determined, I suppose. So migration is a big issue in the UK, I suppose, and there is a sense of frustration possibly that the European Court weighs in on migration issues under Article 8, typically, of the Convention. And it's leading to some politicization of the human rights issue in the UK. We might also be seeing some erosion of the UK's Human Rights Act. Even though the Bill of Rights bill was withdrawn, we do see in a couple of one recent act and another bill that's before Parliament. So in the Illegal Migration Act and the Victims and Prisoners Bill, we see provisions that would remove the Section 3 interpretation power in the context of these pieces of legislation. So we see, I suppose, a continuing concern about Section 3 not being a helpful or appropriate power for the courts to be exercising. So perhaps the Conservative Party or the current government is more comfortable with the Section 4 Declaration of Incompatibility approach that throws the issue back to Parliament and the government, rather than the courts themselves reinterpreting or interpreting legislation. Interestingly as well, the Illegal Migration Act did not receive a Section 19 statement from the minister saying it was compatible with convention rights. So that's potentially quite a significant development as well. So I think I'm, yes, roughly on time, which is good. So I'll just make some concluding observations. So the UK's Human Rights Act represents a distinctive approach to human rights protection, different from US-style judicial review under the US Constitution. It's not totally distinctive, though. It's similar to other Commonwealth models, as they've been termed, in which the courts don't always have the final say over a rights issue. And there are other pieces of legislation that are very similar in approach. For example, New Zealand has its own human rights legislation that operates somewhat similarly, although I don't want to say it's exactly the same because that wouldn't be true. But there is an overlap at least. And in Australia as well, some of the states have legislation that resembles the UK's Human Rights Act. So it's not entirely unique in the world, but it's a distinctive approach, and it's novel compared to systems where the courts have more power. And as I've said, courts don't have strike down powers. They have this reinterpretation power under Section 3, or they have a declaration of incompatibility power under Section 4. But these are still significant powers, and they're still controversial in the context of the UK's political system. So as I have outlined, there have been tensions between the UK government and the European Court, and there have been some controversies over the UK's compliance with human rights norms, particularly this issue of migration and asylum seekers. That's quite a... Okay. Oh, can you stop recording, actually, because I'm now going to go to Q&A. Sorry, could you stop the recording before we start the Q&A?